Welcome to the TRU Law Podcast, a podcast that covers key decisions across Canada's courts. Today you have me, Ayomide Maxwell, otherwise known as Ayo, as your host, who is also a second-year law student and president of the podcast. Today we'll be going into the Crown and Pawlowski, a case that deals with a speaker at the COVID-19 blockade in southern Alberta. This case delves into the difference between free speech and speech that is incitement of criminal conduct. We also have Professor Robert Diab joining us today on the podcast. Professor Diab is a key member of the Faculty of Law at Thompson Rivers University, where he teaches and researches topics like constitutional law, criminal law, and human rights. He's also the author of the Harbinger Theory and co-author of Search and Seizure, tackling some of the biggest legal issues of our time. Outside the classroom, he is associate counsel at Jensen Law, working on appellate criminal cases. With his extensive experience and fascinating research on everything from post-9/11 security to AI regulation, we're excited to hear his insights today. He will be helping us draw the line between free speech and inciting criminal activity. He will also outline what is expression under the Charter and when does speech fall under the Charter and when is it not protected by the Charter. We hope you enjoy our episode today and we hope we see you around for more in the future. Thank you, Professor Robert Diab, for joining our podcast today. Super excited to have you here. I'll just give a little bit of a background about the case and why I decided to select it. So I was reading on one of the newsletters I get that keeps me up to date with the law about different cases, and they mentioned the Crown and Pawlowski that dealt with freedom of speech versus incitement of crime, specifically criminal mischief and the COVID-19 trucker blockades. And I thought, given the timing and given down south, President Donald Trump being elected, also being charged with incitement of criminal activity, I thought this would be an interesting perspective to look at the Canadian side of things. And so I guess my first question I'll ask is, what are your general thoughts about this case and how the judges decided it?
Yeah, well, maybe we should say very briefly what happened and just be very brief. The accused in that case drove down to the border where a number of cars were parked blocking the border in protest of the COVID policies, the mandatory vaccination policies of the federal government. And the accused in this case walked into a bar that was right across the street from where the cars were parked and essentially had a megaphone and gave a speech supporting them, but encouraging them to continue. So the point was they were already doing it, and what he was saying was, don't give up, don't back down, keep up the fight, language to that effect. And he was charged with inciting, counseling mischief, and was convicted, and he appealed it, and the Court of Appeal upheld it. And so very briefly, what the judge found at trial was that even though he didn't counsel them to start the protest, by counseling them to continue it, he was committing mischief. Defense in the case had argued that he was merely expressing a political opinion. He was merely exercising his charter right under 2B to express, the political view that he thought that the federal government was deeply mistaken and so on. That was either not mischief, not incitement to commit mischief, or it was a lawful defense for doing so. So to be clear, by the way, I should have made clear at the outset that you commit mischief when you interfere with someone's right to enjoy, the use of property, and that can include a public roadway. So blocking the road, blocking the border is mischief, and he was encouraging, he was abetting, you could say, he was counseling them to continue to commit mischief. And briefly, the trial judge said, no, it was not primarily political speech. It had that element to it, but it was primarily criminal because its intention was to incite them to continue blocking the road, and that was a criminal act. And maybe we'll get into it in a minute as to what the Court of Appeals said. But I think there was some merit to both the decision at both levels of court.
Mm-hmm. That's a pretty detailed take, and I appreciate that. And I did pick up on some of those, what I call gray areas, which we'll be questioning you on at the moment. So first, in paragraph 17, actually, Justice Woolley holds that in a free and democratic society, speech and people's ability to express their opinion should be free without fear of prosecution. And specifically, it looks at the part of the counseling requirements that deliberate encouragement or active inducement cannot encompass speech that's political. So what part of his speech do you think pushed it from political speech to being criminal speech?
Yeah, so the trial judge goes through a number of features of the speech, things that the accused said, but also the general context. He pointed out the fact that it was said, he was speaking at the microphone or the loudspeaker, and so he knew that he wasn't just communicating to a group of people at a table. Mm-hmm. He had the audience. He had the ear of the entire audience. It was in the context of a protest in progress, and he had gone all the way from, I think, Calgary all the way to the border to be part of the protest. And the central message of it wasn't simply something like, hey, I think I approve of what you're doing. I think you guys are morally in the right. It was, don't back down. Keep this up, So it demonstrated more than simply an intention to kind of pat them on the back, you could say, or express solidarity with them. It was an active gesture of support, encouragement, incitement.
No, I completely agree on that. I know from the case itself, some of the things he mentioned was like, don't lose your momentum. Here's the opportunity to hold the fort. Don't break the line. They can't arrest us all, or we've started something they can't stop. And I can see the judge's reasoning that that might push it across the line into more incitement of criminal activity rather than free speech. But on that note, I know one of the justices commented that his speech went beyond, and I quote, expressing sympathy, expressing admiration, or just planting seeds. What exactly does planting seeds in the minds of the blockaders look like in a situation like this, or expressing admiration? Let's say someone, for some reason, wanted to be the next Mr. Pawlowski, but he wanted to avoid criminal charges. How would they make a speech that, I guess, rallies them politically without inciting criminal activity?
That's a great question. In other words, where was the line that the court was drawing or was saying that he had crossed? And I think maybe one way to think of it is if he had simply said something to the effect of, what you're doing may be criminal, or you're going to pay a steep price for what you're doing, but I admire you for that. I think that's the right thing to do, or that you are justified in doing so. He crossed that line, it would seem, by making a number of statements that actively incited, did more than say what you're doing is a good thing. He was trying to persuade them not to stop.
That's pretty good explanation of that side of things, just because I did have a little bit of confusion when it said, oh, it's not like he couldn't make a speech at all. He just had to make it in a way that wasn't inducing. But what exactly did not inducing really look like? But now we'll move on to one of the other appeal grounds Mr. Pawlowski argues is that his speech was protected by the Charter, specifically Section 2B. And so first, I understand that Part 2B of the Charter doesn't protect criminal conduct, but let's put that to the side for a moment and talk about whether or not his actions or the blockade could be considered as expressive. In Toy, it says for an activity to be protected under the Charter, it has to be considered as some sort of expression. And so what do you think? Do you think a blockade can be considered expression, like expressing their frustration with being forced to take the COVID-19 vaccines? Do you think that blockades don't really fall under the term expression in that context?
It's a great question, and you're putting your finger on, I think, what intrigues people about this case. You're right. Okay, that is absolutely at the heart of it. In other words, obviously the blockade was a form of expression. And if we have the freedom of expression in Canada, it would seem to follow that the government can't simply shut it down or even criminalize people for doing it because it takes a different political opinion. If that's the case, then we don't have freedom of expression in Canada, or at least, you want to be shown why that's not a subversion of your right to free expression. And so in this case, there were sort of like two responses, and you can decide whether you're happy with them. The majority, two of the judges of the Court of Appeal agreed with the trial judge, which is, they said, look, if you're arguing that the Charter, your free expression rights, give you the right to express this view, and therefore to break the law and block the border, you had to sort of fill out forms. You had to provide notice that you were going to make a charter argument. The proper way to have done this would be to argue that the criminal code offense of mischief and incitement, counseling, that those infringe Section 2B of the Charter, and you didn't do that. And because you didn't do that, you can't make that argument now. But the concurring judge, like a third judge on the Court of Appeal, went a little further. He was sort of intrigued by this, and he agreed with the other two. He agreed with the other two that no, you can't make that argument. But he explored it in more detail and said, look, I don't think it's a violation of 2B for two possible reasons. One, inciting people to block a public road is not a protected form of speech under 2B. So the Supreme Court of Canada has said that speech that is in itself criminal, like uttering a threat or inciting a riot, is not protected. It doesn't engage 2B. 2B isn't breached if that speech is curtailed. But he also hinted that if it is protected, so like having a blockade of the border does fall under 2B. Curtailing it, saying no, you can't do that, and doing that is criminal, would be a reasonable limit of the right under Section 1. But he only hints at all of that. He sort of sketches that response, because again, officially, the case wasn't framed as a challenge under 2B.
Yeah, I guess that is where the procedural and substantial aspects of the law really clash. And I was actually surprised when I read that and I heard that they didn't make the charter challenge originally, because before reading the case, I was thinking, bang, free speech versus, inciting criminal activity. That would be where it would go. But I guess his counsel decided that wasn't the case, unfortunately, until it was too late. But on that topic, what's your opinion? Do you think that it should be protected under 2B of the Charter? I know they said the Charter defense holds, but under Section 1, it's reasonably limited under a democratic society. I did agree that I think that is a reasonable limit to a charter right, but I'd like to hear your opinion.
It's a very hot topic at the moment. It was really the topic, I think, that was on a lot of people's mind over the summer with the protests about Gaza. So something analogous was taking place across North America, at campuses around the world, really, but certainly across Canada, where people were not necessarily committing mischief, but they were, or perhaps you could argue they were in some cases. They were engaged in what could be called trespass, but they were arguing that they're entitled to exercise their freedom of expression. And the issue that courts had to grapple with is that at some point, your freedom of expression rights under the Charter come into conflict with property rights, the rights that property owners, including the government, but also private entities have to the enjoyment, or citizens or students have to the enjoyment of the same property. And so there were different answers to this question across Canada, whether 2B could to be recognized and protected a form of expression that involved, commandeering public space indefinitely, for like the whole, months on end, or whether it didn't go that far, or whether it did, it should be limited under Section 1 of the Charter, which allows for a breach of your rights where the breach is reasonable. And we never got a sort of simple answer to that question. I think this is maybe a variation of it. This is the question. So one way to answer the question is that no, not only does 2B not protect violent speech, like uttering threats or like inciting a riot, it doesn't protect speech that it counsels people to commit a crime. That would be one, I think, rational way to frame it, and there's case law supporting that argument. Or another way would be to say that, okay, fine, maybe it does protect this kind of expression, but it should be limited under Section 1 beyond a certain point. So maybe, like, for example, you can have your protest for a few hours, okay, or maybe even like a day, but beyond that.
I think that's a completely reasonable way of looking at it. I definitely agreed that the Alberta side of me is coming out saying free speech, but there does have to be reasonable limits to our charter rights. I guess a couple final questions. So, an interesting parallel, I mean, the answer is probably pretty clear, but I know in the case Dolphin Delivery, Justice McIntyre held that it was legal for picketers to engage in economic interference to put economic pressure on their employer. And I kind of drew a little bit of a parallel to this scenario where they're putting economic pressure on the government by holding up the border, one of the busiest border crossings between Canada and the US, to try and get the government to change their ways. And also, sorry, I make this a little bit of a compound question. In Trowland, the court held persuasion is different from compulsion. When you are doing a protest, you have to be, or you're using communication. Communication needs to be persuasive rather than compelling. When it becomes compelling, it's not as much protected under Charter Section 2B. So now, with that information, what do you think the comparison between the picketing versus the blockading? How come picketing is legal and blockading isn't, even though to some extent they do the same thing? And then how would you make the convoy protest, I'd say, communicative or persuasive rather than compelling?
It's a great comparison. You're right. In both cases, in the case of picketers, strikers, in those cases, you've got the tension between, the freedom, the liberty, the commercial interests of the employer versus the freedom of association rights under the charter of the strikers, of the workers. Here, you similarly have the liberty interests of affected members of the public, and you have the expression interests of the blockaders. And it may be the case that there's no answer here, that as soon as you decide to blockade, rather than merely honk your horn at the border, like have like a whole bunch of cars and trucks in the shoulder of the highway, and waving signs and stuff, that would be persuasive. But maybe the line to be drawn for 2B in this case is at compulsion. Like, you could say that because they're doing more than merely expressing, they're compelling people. We have to draw the line at that, and we have to say, no, you're not entitled for any period of time to block the border, because that's not fundamentally expression. That crosses the line from expression to compulsion, and compulsion is a form of violence. And so I think that's a plausible way of looking at it.
Okay. No, I definitely seen some of the protesters honking their horns. I think one of the comparisons Mr. Pawlowski actually made in his speech was that we have to do more than just honk our horns around Ottawa, but actually, do real damage, so to speak, which is probably what pushed him across the line from political speech to criminal speech. But I think that'll wrap up my questions on this case. I want to thank you so much for coming on here, for giving people really just your insight and your knowledge. The way you even broke down the case was way better than the breakdowns I'd managed to come up with. I guess any final thoughts you want to leave the listeners with today?
No, I think that was great. I'm delighted to be a guest on your podcast.
Awesome. Thank you so much. Well, we'll see you next time.